try to go through the other ones quicker. Sorto-Guzman v. Garland out of the Fourth Circuit. First of all, I must discuss it because the attorney is Jeremy McKinney, who is the AILA president. So he gets his props on my show and now yours because he's AILA national president. But also because this case is just awesome. The Fourth Circuit is the tip of the spear on asylum case law. And you'll find the best precedent on almost all aspects of asylum. And
where is the Fourth Circuit?
Fourth Circuit's Maryland, Virginia, and I'm not sure who else.
East Coast over there. Okay.
East Coast, yeah. And it's not just the judges who are appointed by Democrats. Judge Quattlebaum is a Trump appointee, and he's got some of the most impactful decisions since I started the podcast 2.5 years ago. Sorto-Guzman is good for two reasons. First of all, it's the Fourth Circuit reiterating strongly that just the death threat without anything else is past persecution. Like, this is all over the circuits, and some circuits want to say you got to show harm, but no. And past persecution is so important because once it shows, the burden shifts to the government. There's a presumption of a well-founded fear if you show past persecution. And so the judge who doesn't want to grant will be arguing that you haven't shown it. But the Fourth Circuit, they say it twice in a row on purpose, and they italicize it in this case. The threat of death alone is past persecution without anything more. Now, there's a there's a little more. No requirement for harm. I mean, it must be. Can't just be flippant, right? Like, not some guy walking down the street saying I'm gonna kill you and they're mentally ill, that kind of thing. But a death threat alone. This is also important.
Actually, how do you prove it? Is it just hearsay kind of thing? Like, this person said it? It's not good, right?
Like hearsay is admissible in immigration court. Sorry about my face, by the way. They got a light in my room, and the sunlight keeps changing, and I'll try and stay back. But how do you prove it? Hearsay, they testify, but you get sworn statements from friends or family who are in country who know about it. And, with all the technology, when I'm putting these cases together, though, I mean, there's often a wealth of evidence in WhatsApp messages, on Facebook. And the other side sometimes is using that as well. I mean, be careful. Sometimes people will say, like, there was a case a couple months ago where the guy is like, I was in hiding in this country in Africa for 6 months. I couldn't do anything. And then they showed that he had been posting on Facebook during that time. He's like, you said you didn't have electricity. How were you posting on Facebook? And he's like, So be careful, check social media. But you can use that to your advantage, too, to get evidence. And that's why credibility comes into play in these cases, because hearsay is admissible. And so once the immigration judge says, I believe you, it becomes much harder to deny a case. But Sorto-Guzman is also very important because she was harmed outside of a church, and gangs ripped off her cross and said something bad about Christians, Catholicism. And then, like, a couple more times, she was abused. She was beaten pretty savagely, and she was extorted in manners that I think everybody agree is probably not persecution, because it was not because of a protected ground. But the religion one was. Mm-hmm. And so the Fourth Circuit is saying, look, you have one. All you need is one, judge. Yeah. That's past persecution. They ripped her chain. They threatened to kill her. That's past persecution. And those other things, that by the same gangs, that just goes to show that they are willing to follow through. It doesn't matter that it wasn't on account of a protected ground later. So I thought that was an important thing, because nexus to a protected ground is always a way that these cases are getting lost. All you need is one. Fourth Circuit reminding us.